stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. Mark Chenoweth and John Vecchione with you, and we have a special guest in the studio today, fresh off of her victory at the United States Supreme Court, our colleague, Senior Litigation Counsel, Peggy Little. Welcome back to Administrative Static, Peggy.
Very glad to be here, and very glad for the reason to be here.
Well, and congratulations on your victory. I guess maybe we should start by reminding folks. So there's one sort of little complication that maybe we should start with. So the name of the case is SEC v. Cochran, and you had argued this case successfully at the Fifth Circuit, and then the government, the SEC, had appealed this up to the U.S. Supreme Court. The Supreme Court agreed to hear it, but then they sided with you and your client. But the name of the case is Axon v. Federal Trade Commission, which I think is going to be slightly confusing to people. Maybe you can explain, we can start off by explaining, why is there one opinion written for two different cases that were before the court?
Good question. Axon was a case out of the Ninth Circuit Court of Appeals, and it had been working its way up through the system on a very similar issue under the Federal Trade Commission Act. And that is whether their administrative law judges were unduly insulated from removal under the FTC statutory scheme.
Which, as you say, is the same as the issue in Cochran, as whether the ALJs at the SEC were unduly insulated from removal.
Exactly. And when we first took on Cochran, we had 5 circuits against us. As Axon worked its way through the system, we suddenly got 6 circuits against us because the Ninth Circuit ruled against Axon with a good dissent by Judge Bumate on that court. But Axon really wasn't going to go anywhere because there was no circuit split. In Cochran...
And just to clarify for our non-lawyer audience, when Peggy refers to a circuit split, you mean that a lot of times the Supreme Court doesn't want to hear a case unless there are some courts of appeals going one way and other courts of appeals going the other way. And here, all the courts of appeals so far had all gone the same way on this issue.
Exactly. And so anyone's chances of review at the Supreme Court are very low to begin with. But in this type of case, you really do need a circuit split to advance to the Supreme Court. And in our first round on appeal with Michelle, we also lost sort of like Axon did, in that we got two judges against us, but a good dissent. We tried to get en banc, and we succeeded. And that case was argued by us in January of 2021 before 16 judges of the Fifth Circuit Court of Appeals. And they took a while to rule, and that's why the Axon ruling intervened at that point. But in December of 2021, we received the decision of the Fifth Circuit Court of Appeals for the first time ruling in our favor on this question. That immediately created a circuit split. Axon's case...
Axon had already applied to the Supreme Court for a cert petition at that point, if I recall correctly.
That's true. And that cert petition was granted. And so the reason why Axon appears first on the case is they were up on a cert petition before Cochran was, even though our favorable decision at the Fifth Circuit helped launch them to a successful petition for review at the United States Supreme Court.
Yeah, and you can tell that because the case number for Axon is 21-86, which means it was one of the very first cases that sought cert in 2021. And in Cochran, the case number is 1,239. So a little bit later in the year.
Yeah, it came along late, but just in time for Axon's benefit. And we were glad to see that. We had supported Axon in their petition as well. So what had happened was then the SEC filed what they called a hold petition and asked us to agree whether the Supreme Court could just not hear our case until it made its decision in Axon. And we declined that invitation because they are two different statutory schemes. Michelle Cochran has her rights to have her case decided under the SEC statute. And so after some briefing on that point, the U.S. Supreme Court granted certiorari for the Cochran case. The cases were combined. There was a combined briefing schedule. And
the government only filed one brief in response to both parties.
That's true, but there was expanded time for argument, and both the Axon attorney was able to present their argument separately as we were able to present our argument separately.
Well, okay, so let's jump into the merits then. The Supreme Court decided for your client and said that there is jurisdiction to hear this kind of objection to the Securities and Exchange Commission's administrative law judges, and did so under these so-called Thunder Basin factors. Thunder Basin is a prior decision of the court, and before asking you whether there's any problem with the Thunder Basin factors, maybe we can just rehearse what those are and why the court decided that each of those factors went in your client's favor.
Sure. Thunder Basin is a existing Supreme Court precedent, and it has a 3-factor test. Would the appellate scheme under the statutes that only allows an Article 3 court to hear a petitioner's case only after they've gone through the administrative process, would that provide meaningful judicial review? Was the issue that the appellant had at issue, was that collateral to the merits of the case? And finally, was the issue beyond the competence and expertise of the commission? And thank goodness the Supreme Court correctly applied all 3 factors in Thunder Basin, which we had maintained all along could only be found in Michelle Cochran's favor. These are compelling cases that involve proceedings that are unconstitutional. The question of their constitutionality is collateral to any issue in the case. The commission has no business, expertise, or competence to decide constitutional questions. And finally, on the first factor of meaningful judicial review, you can't possibly have meaningful judicial review if the unconstitutional proceeding has already happened. And now you're trying to say it should never have happened in the first place.
And that's maybe from our perspective, the most important thing that the majority opinion said. I think that meaningful judicial review can't happen if you have to go through the process first, because that was one of the factors that a lot of the other courts below had looked at in these other cases. And they said, well, there is review here because eventually the Court of Appeals will hear the case.
Yeah, and the decision is very clear that if the proceeding has already taken place, there is no way you can have meaningful judicial review. And it's a very correct ruling. I found it fascinating, frankly, that Justice Kagan, who tends to write short and crisp opinions, and she's very knowledgeable in administrative law as well, she did not cite a single one of the lower circuit court cases that had held the other way.
Yeah.
And in fact, Justice Gorsuch, and we'll get to this later, but he cited one of the dissents, one of the early dissents in those cases. So what we have is a situation where the Supreme Court rules contrary to what was then 6 circuits. And
essentially saying you're doing it wrong, and here are the exact same factors that you were doing it wrong with before, and we haven't changed them. Keep trying. Like they didn't change the factors. They didn't really add any clarity. They just reversed almost without guidance.
Yeah, and it would be very unusual for a court to do that without mentioning the other opinions and the analysis they had gone through. We maintained all along that this was fundamentally illogical and irrational, because you cannot force a person through an unconstitutional proceeding and then go to a court and later say, oh, wow, that was not constitutional.
Right. What's your remedy?
It cannot be meaningful judicial review. So it was refreshing to see the court take it on, doing its own analysis, not even bothering with the analyzing or critiquing the lower courts. It just did it right. And so we were gratified to see that.
And then what about the other two factors? What did it say about those?
Oh, absolutely. It said on the meaningful, well, starting with the meaningful judicial review, you can't have a proceed that's unconstitutional and call that meaningful judicial review. Also, the question as to whether the tribunal is competent constitutionally to hear the question is key, and the tribunal of the ALJ did not have either the competence or the expertise to decide those questions. Furthermore, whether the ALJ is unconstitutionally insulated from removal is a collateral question. It does not bear upon the merits of the case.
I like what this was in the context of the Axon portion, talking about the FTC, not the Cochran portion of the opinion, talking about the SEC. But I liked when Justice Kagan said that the FTC might know quite a bit about the antitrust laws, but they don't know anything about this aspect of the case, and that's absolutely right and the right conclusion to draw. We're going to leave it there and pick it right back up. Great. Welcome back to Administrative Static. We're here with Peggy Little, fresh off of her victory at the United States Supreme Court in SEC v. Cochran. And we were just talking about the Thunder Basin factors and how Justice Kagan's unanimous decision for the court, the opinion wasn't unanimous, but the decision was unanimous. And 8 justices signed on to her opinion. And one of the things they said was, and this is quoting the opinion, a proceeding that has already happened cannot be undone. Judicial review of Axon's and Cochran's structural constitutional claims would come too late to be meaningful. Axon and Cochran will lose their rights not to undergo the complained of agency proceedings if they cannot assert those rights until the proceedings are over. I thought that was fantastic. And then the other piece that I was referring to that Justice Kagan said in talking about the expertise of the commission, she said the commission knows a good deal about competition policy, but nothing special about the separation of powers. And so, that was the essential outcome. Peggy was saying about this case was reapplying the same old Thunder Basin factors that all the courts below had applied, but just doing it differently and better, I guess. So hopefully, Peggy, the lower courts will learn from this and will sort of take the hint that, hey, just because we had a couple of cases in there like Elgin where we had applied the factors not to find jurisdiction, that doesn't mean that applying the Thunder Basin factors will always lead to no jurisdiction.
Yeah, it's a refreshing look at the Thunder Basin case, and it does apply the factors correctly, as we maintain lower courts had not done.
And then I think one of the interesting things, maybe the most interesting thing about this case, is that even though they agreed with the decision, both Justice Thomas and Justice Gorsuch elected to write separately and emphasize a couple of different things. And if it's okay with you, I'd like to start with Justice Gorsuch, actually, because he focused so heavily on Michelle's case and he, he sided with the court on the decision, so it's a unanimous decision. But he wasn't a big fan of the application of the Thunder Basin factors, was he?
No, he was not, and no wonder, because the courts apply it so poorly. You have a case here where the Supreme Court reviews those factors and essentially overrules 5 circuits that had not done the analysis correctly. Justice Gorsuch says that jurisdiction rules should be plain and easy to apply. Thunder Basin is not. It's a multi-level test. When those are used by courts, very often they get murky and they allow the judges to rule in contradictory ways, as is proven by the record in this case. And what is more compelling here is when you have a rule like that, you can have people like Michelle Cochran and also Axon go through enormous years-long process before they can get to a court that can properly rule on their claims.
Not only is it very expensive, but a lot of times, even after they incur all that expense, the courts might reach the wrong conclusion. I mean, I haven't looked. You have. I haven't looked carefully at the other 5 cases where the courts had ruled no jurisdiction. But my guess is that you would think, based on this decision in Axon and Cochran, that maybe some of those cases should have gone the other way too.
I would more than think that. I think that there were no differences in factual or legal claims in those cases. And this decision effectively overrules the 5 SEC ALJ cases.
Did you want to mention the dissent in the Second Circuit? You alluded to it earlier.
That's true. As I say, the 5 cases that were kept being cited again and again by the SEC against us weren't even mentioned in the case. And the only case that was mentioned is a case called Tilton out of the Second Circuit, in which the first dissent by an appellate court appeared by Judge Christopher Droney, and Justice Gorsuch cited
a Clinton appointee, if I'm not mistaken.
Yes,
Judge Droney.
Judge Droney cited to, Justice Gorsuch cited to Judge Droney's dissent, which was a powerful and well-reasoned dissent that explained why the courts were not applying those factors correctly. Justice Gorsuch argues for throwing out the Thunder Basin case altogether, and I think he's right.
And how would he decide the case then? If you throw aside the Thunder Basin factors, how do you know whether there's jurisdiction for a federal district court here? I mean, Section 1331 gives the federal district courts jurisdiction over all federal questions, but is that the end of the matter?
Well, Justice Gorsuch takes it on straightforwardly. It's a pure statutory construction case. Section 1331 confers jurisdiction on the federal district courts for all constitutional questions. Nothing in either the Securities Act or the FTC Act takes it away. Therefore, as a statutory matter, this Michelle Cochran and Axon both had jurisdiction to bring their claims to the district court. That is a clean and easy to understand rule.
And a hard one to get wrong if you're applying it as a lower court, I would think.
Precisely. Then there's a lot of case law that says if a federal court has jurisdiction, it does not have discretion to decline that jurisdiction. That has been conferred upon them by Congress. And especially when it's a constitutional claim, the courts must take that assignment of jurisdiction seriously.
I like the way that Justice Gorsuch puts it. He says, while the court reaches the right result today, its choice of the wrong path matters, not because continuing to apply the Thunder Basin factors leaves the law badly distorted. It also matters, or not just because that, it also matters because Thunder Basin's throw it in a blender approach to jurisdiction imposes serious and needless costs on litigants and lower courts alike, as you were referring to earlier.
And he goes through in painstaking detail exactly what those serious costs were. He talks about
Michelle Cochran.
Michelle Cochran's painful journey through the court system and the administrative law system. And
several pages on that.
Indeed. And he presents her case compellingly and persuasively. And when you read it, you say, oh my gosh, how can this happen in America to anyone?
That's what we said when we took the case.
We did indeed. And he shows her going through this whole administrative treadmill. It's just cruel. And then he says, this is what a win looks like under Thunder Basin. When you replace clear jurisdictional rules with a jumble of factors, the room for disagreement and error grows. And it's a very compellingly written opinion. I think that the combination of the Supreme Court effectively overruling those 5 cases and then Gorsuch's plea that the test itself is very confusing might suggest that Thunder Basin has at least diminished authority.
Yeah, I think there's certainly enough here to persuade any court who wants to hear these cases to find jurisdiction in the future. I'm still worried about those cases that don't want to find jurisdiction. They may still have wiggle room here as well. But before we run out of time, let's jump to Justice Thomas's concurrence, because he did something even more fundamental than what Justice Gorsuch did. He essentially said, well, this whole administrative adjudication system is not necessarily copacetic. And maybe I should give a plug for our fearless founder and leader, Philip Hamburger, who was cited multiple times, both by Justice Thomas and by Justice Gorsuch. But tell us what Justice Thomas said about administrative adjudication more broadly.
Well, Justice Thomas goes back to the fundamental principle that when it comes to questions of life, liberty, or property, those matters have to be decided in courts that Article 3 courts that have jurisdiction over those core private rights. He is troubled by this, what he calls an appellate review model that makes people go through this administrative system and then only get to an appellate court years later. He said it violates the separation of power by placing adjudicatory power in Article 2 agencies such as the SEC and FTC. He also thinks it may violate Article 3 by compelling the judiciary to defer to administrative agencies regarding matters that involve core property and personal rights, and cites Professor Hamburger. On that, he said it violates due process by empowering entities that are not courts of competent jurisdiction to deprive citizens of their core private rights. And finally, he adds that it also deprives them of a right to a trial by jury, which is a constitutionally protected right. All of those things are at stake. All of those things are going to be currently at stake at the Supreme Court due to another case coming up before the court. And so,
and the majority doesn't come down on any of those questions. It just says we don't need to reach those today, or to the extent it refers to them, it says we don't need to reach this other set of questions.
But it's not uncommon when there's a concurrence or dissent with which the majority disagrees. You get some back and forth in the opinions. That's not here. And so Justice Thomas lays out a very compelling set of reasons as to why there are multiple reasons that Michelle Cochran and Axon could get into federal court to protect their constitutional rights and their constitutional liberties. And Justice Gorsuch does the same.
But you don't take it as a bad sign that no one joined Justice Thomas's concurrence?
No, I think that they, there's something known as judicial economy, and I think that most judges say, well, this is enough to decide the case. We will go no further.
Let's keep the focus on unanimity today. Is that the...
I think so, but that's it's great to have a unanimous win, and it is worth pointing out that we were defeated in 7 circuits until we got that en banc win at the 5th Circuit. And so people need to persist and have faith in litigating their constitutional rights, because sometimes they don't come easily.
Well, I think the other takeaway from this case is that Peggy Little is a good person to have on your side. She's undaunted, even facing 7 courts of appeals against her, and was willing to go to the en banc 5th Circuit, argue successfully, get this case to the Supreme Court. And thanks to Greg Garr at Latham & Watkins who argued this case. We've thanked him before here, but approach to do so again for his argument at the Supreme Court. Peggy, thanks for being with Administrative Static and getting this great victory in the SEC.
Thank you, Mother.